SJC-13636, Commonwealth versus Weber J. Andrade.
Okay, Attorney Levert.
Good morning. May it please the court. My name is Suzanne Levert, and I represent Weber Andrade. I don't believe that Mr. Andrade got a fair trial this time because his trial attorney refused to admit a specific, relevant, violent act that would have helped the jury assess, would have created a fuller picture for the jury to assess his defense of self-defense. In addition, she failed to instruct on defense of another, which she herself recognized in the course of the trial, and doing so was prejudicial error. I think that Mr. Andrade deserves a new trial.
If that evidence of the victim's post
Subsequent.
subsequent behavior had come in, tell me how it would have made a difference.
Well, it would have. The issue was, as you know, in these cases, is who was the first aggressor or who escalated the assault. And I think the record is unclear to the jury. It was seen on very fuzzy surveillance tape, and the testimony of the witnesses were conflicting. We know that there was a physical interaction between Weber and his father.
But the father started it, right?
It seems.
Well, I mean, that would be best for your client.
Yes, I know, yes.
Okay, so the father started it, apparently.
Apparently. And he was also a bigger man, and he forcefully pushed his son. But then the son leaves and goes downstairs. The father follows him. And what happens in that minute or so before the stabbing takes place is unknown. No one knows what that is.
There was a video. There was a video of your client in the driveway, which I take it was before the stabbing?
It was both before and after.
Okay, and there was a second man in the video. The second man was not the father, was it?
No.
Okay, so at least we know a little bit about what happened before the stabbing, and that was that he was not with the father, but he was with another man.
I believe, I could be mistaken, but I believe that the scene with the other man was following the stabbing. That was just before Weber left the scene altogether.
Okay.
And it would have been nice.
Is that also the moment when the video shows him with the knife in his hand?
Yes. Now, it would have been nice if that man that he was with was ever found by police and questioned. He was found by police, but they failed to question him thoroughly or take a statement from him, so we have no idea what his perspective on the event was.
Was there any evidence that the father was in close physical proximity to the defendant's wife before the stabbing?
Well, her testimony is that he came at her and was pointing a finger in her face.
That was on the stairs when she was downstairs and he was upstairs. Right. So my question was a little bit different. My question was right before the stabbing. So this is not on the stairs. Okay. This is down in the yard. Was there any evidence that the father was in close physical proximity with the defendant's wife?
It's a confusing piece of evidence, but he testifies that she was coming towards him and talking to him, but he did not understand what she was saying and didn't have a conversation with her, but she was coming towards him and talking to him, and he was still yelling at her.
So how would that help defense? How would that help support a theory of defense of another if the victim is approaching, if the wife is approaching the father? Because she would be going towards the harm rather than needing protection from the harm.
I don't think that would support that, but there was
Okay, so then how does your client get to piggyback on her for defense of another?
Well, the judge herself brought that up because she heard the testimony of him coming at her and continually yelling at her and being very aggressive with her throughout, even after he was stabbed. He got back on that porch and was yelling at her and telling her she could not come into the house again, even to get her children. He was very, very angry. And I would think we're all supposing these things, but I would think that if I were a husband and saw a father that aggressive towards the wife and pointing at her and putting his finger in his face and coming that close to her, he would be upset.
Now, we've discussed prejudice, but let's get to the legal issue about whether it was error on the adjutant instruction. I take it from your brief that this issue of subsequent misconduct has not been decided by our adjutant cases, correct?
It seems not.
Okay. And we can look at bad act evidence, misconduct evidence for analogy. And I think we allow subsequent misconduct. It's not uncharged. It's uncharged misconduct, not prior bad acts. It's a misnomer.
Right.
Why should we have the same rule for adjutant when adjutant is a carefully, narrowly prescribed law that is essentially propensity evidence? So why should we align the two doctrines?
Well, I think the thing that got me started on this was realizing in adjutant itself, knowledge by the defendant of the victim's act was not required. He didn't need to know.
Right, that's the old law. That's Fonts and Pidge, right? So we've said, just to the extent that it allows the jury to, gives them details on who the likely first aggressor is, we're going to allow this.
And so temporality doesn't seem to make a difference. And what I think the judge in this case did not do is weigh the evidence, probative against prejudicial. She didn't weigh it. She just said, nobody's ever said subsequent, so we can't say it's always prior, it's always prior. But as we saw, the amicus brief that was submitted went through the 5 states that have a similar adjutant rule, and they found that subsequent bad acts are just as relevant. If they're relevant to the issue, they're admissible.
But how could it be error for the judge to do something that we have never explicitly said the law recognizes? How could that be error?
Well, if you look at what happened in adjutant itself, the way the court ruled was that judge did not make it. What she did was understandable, and yet we rule that she made a mistake. It was a mistake of law. I mean, it's just a mistake.
Can you just walk me through the rationale for extending adjutant to subsequent acts?
Well, again,
given that, as Justice Gaziano was pointing out, it's a really narrowly crafted exception, and in adjutant itself, we were following a near universal slew of jurisdictions that allowed that kind of propensity evidence in.
Well, again, what hooks it for me is that if the victim if the defendant does not need to know, if his knowledge is not the point, whether he knew or not, it's how the information can be used to educate the jury about the events of the night.
But didn't, one of the reasons that the trial judge did not allow it was this theory, whether or not it's valid, that because the victim had been stabbed, he became aggressive subsequently, and so the subsequent acts do not necessarily tell us anything about his aggressive nature in the moment.
Perhaps, but that would be what the jury would weigh. It's the jury's province to look at the evidence and weigh it. Not an admissibility question, it's whether they believe it or not, or whether they would assess it to be in the favor of the defendant.
Should we consider that factor in assessing how probative that evidence is?
I think
The
it
judge,
was-
the
I
judge
think-
didn't do a 403 analysis, but
No.
should we consider that when we decide whether it's either probative and/or prejudicial?
Yes, I think so.
Sorry, can we go back to the question that the chief started off with, which was, can you just walk me through quickly in this case, how was it relevant? And in your answer, can you address that the judge actually, as far as I could see, did not instruct on first aggressor. The judge instructed the jury that the defendant could not raise self-defense if they found various things, but one of them was not first aggressor. It seems to have been uncontested that there was a video that, and so can you address, and so it's not first aggressor, and it's not the defendant's own knowledge, because this is a subsequent act by the victim. So how exactly is it purportedly relevant here?
Well, I think it's very relevant because the act that was suggested to be admitted, proffered to be admitted, was an assault by the victim of his own wife, who was also there that night. This is a whole family event, this happened. And if you read the evidence carefully, the fight, the issue of the fight was proffered in the kitchen between Jose Andrade and his wife, Hope. And that's who Jose assaulted a year later and pushed her to the ground. And I think that would help the jury understand the dynamics of this family.
But it wasn't really contested that the victim was upset and was lashing out and was pushing the defendant and so forth. So, I mean, how does it actually, you said at the beginning, this fills out the picture of what occurred. And can you just very precisely say, what is the fact that it makes more, what is the fact that it makes more probable that was relevant to the jury's conclusion?
Well, I disagree. I don't think that the surveillance tape was that clear of what was happening between them. And so evidence that Jose had this violent nature would be relevant to the jury when assessing the facts that look, on the surveillance tape, and would help them decide if the self-defense claim was more likely than not to be relevant. I think it would fill out the picture, give the jury a full picture of the events.
How would that not be propensity evidence? I'm having a hard time understanding. To me, it sounds like what you're saying is this would be propensity evidence.
It's a very narrow, specific act. It's not a reputation, it's that he behaved in this way towards this person at one time. And that would be, it's not as if the defense came in and said, we have 6 incidents of this event, of this behavior. It was one event against a person, again, who was there at the same barbecue. And I don't think it's propensity evidence.
What's
with
the
one
time
act.
lag between the charged conduct and the subsequent bad act?
14 months.
14, okay, thank you.
And in other cases that was cited, and I can't remember, my printer didn't work this morning. There were some cases that they didn't accept subsequent acts because, or actually prior acts, because they were so distant in time. They were 4 years behind. Well, this is 14 months. It's not all that long.
Counsel, I'm getting a little bit confused by your argument, so I just want to make sure I have this.
Yeah.
So you're saying that the subsequent act would not be relevant to would not be admissible for propensity purposes. So are you saying that it would be admissible on the issue of who was the first aggressor or who escalated the event? For what purpose would it be offered, is what I'm getting at.
It would be offered for that, to help the jury identify the first aggressor and/or who escalated the fight.
On the second issue, is there any dispute as to who escalated the fight? It seems your client brought a knife to a fist fight.
Well, he didn't bring it. It was there.
Okay,
He had been barbecuing.
you know what I mean.
Well,
You know what
I
I
know,
mean.
but he,
Okay, but he used a knife in a fist fight.
yes.
Okay, so is there any real question as to who escalated this?
Well, it's the why. It's did he feel threatened? What did he feel that his father was so aggressive that it could at any moment turn to be dangerous for him, physically dangerous for him? And the scene in the porch on the deck certainly made that clear. He was pushing him, and he was a.
Okay, and okay, thank you.
Thank you, counsel. Your time has expired.
And I guess the one thing I did want to make sure the court recognizes that in the amicus brief,
We got it.
but that there are other states who also found this same thing, that it didn't matter whether
Thank
it's
you.
before or after.
Thank you, counsel.
Thank you so much.
We have it all. Okay.
Thank you.
Okay, Attorney Wakoni Jang.
Morning. May it please the court, Kristen Jang for the Commonwealth. It is quite well settled that adjutant evidence is one of the few narrow exceptions to the general bar on propensity evidence. When the trial judge in this case excluded the proffered evidence of the victim's subsequent violent act, no published case in the Commonwealth had explicitly extended this narrow exception.
So same question
Yes.
that I asked counsel. We haven't said one way or the other whether or not adjutant is subsequent or prior, correct?
Yes, that is correct.
Other than what you let off with, it's a narrow exception.
Yes.
On uncharged misconduct, that also entails subsequent misconduct, correct?
That is correct.
Why a difference?
Well, and I will concede that the amicus brief filed in this case lays out a lot of really great policy arguments for extending the adjutant principle to post-crime conduct. The Commonwealth does not contest that, and this court is obviously able to make a new rule going forward that adjutant evidence explicitly applies to post-crime conduct. I think the tricky and sticky question here is at the time that the judge was faced with this question, was it?
But if there's no guidance and the judge basically, through no fault of the judge's own, basically could go one way or the other, and we disagree and says because the judge categorically said, no, it's subsequent,
Correct.
it's out. So if we disagree with that, that's an error. And then we get into whether or not there's prejudice, which is a big issue in this case.
Yes, and I'm happy to speak on that.
But would it be error, though, if the judge doesn't realize they have the authority to do something, they don't do it? Is that legal error?
Yes, unfortunately, I think the case law is fairly clear that a failure to recognize discretion is an abuse, is an error of law. I think the judge was in a pretty difficult situation
No, I'm
here.
not saying it was easy, having been reversed and having made calls,
Right.
having made calls that were different, that did turn out to be wrong. I fully appreciate that.
Yes.
So you're now going to argue prejudice?
Sure,
Or
I'm
lack of
happy to move on
prejudice?
to the prejudice.
Before you do that, just one last question on
Yes.
the rule itself. Because
Yes.
the trial judge says, look, we don't know whether this crime itself
Yes.
changed the defendant. You
Yes.
know, there's some logic to that, isn't there?
Absolutely, absolutely. And in reading, actually, the amicus brief was very helpful to me in kind of thinking through the reasoning that other jurisdictions have gone through about deciding this issue. And that was raised in a few cases. I think, though, that when the judge is considering adjutant evidence, there's also a 403 analysis that the judge has to go through. So I think that fits more neatly into that 403 analysis. If the judge wants to have a mini voir dire, perhaps, if that's an issue in the case, that could be hashed out. But the problem is I was able to think of lots of scenarios in my head where a post-crime violent act would be extremely probative of whether the victim was the first aggressor. And the cases that are cited by the amicus brief, are rife with examples of that. So to say that it's an absolute bar for that reason, I'm not sure is correct.
So you would have no problem if we decided that adjutant should be extended to subsequent bad acts or...
Sure, so long as there's still that 403 analysis, which I think there has to be, and this consideration, I think the judge's point that, perhaps the crime that it's an issue may have changed the victim in some ways, absolutely relevant and should be included in the analysis if it's applicable in the case.
Okay, so back to the prejudice.
Sure. On the prejudice issue, so the defendant's self-defense claim in this case was extremely weak. It was presented largely through cross-examination of the Commonwealth witnesses and argument from counsel. The defendant, as he's entitled to, exercised his right not to testify on his own behalf. The proffered evidence that the victim, 14 months after the defendant stabbed him, pushed his wife during an argument would have offered little to support the defendant's claim of self-defense, let alone who was the first aggressor in this case or who escalated the conflict between the defendant and the victim.
Why not?
Because there's a video a few minutes before showing the victim very clearly pushing the defendant. I think that's far more probative than 14 months later he pushed a completely different person.
So your reasoning is it's cumulative?
It's cumulative. The timing is 14 months is quite a long time in this case. Also, this issue wasn't really disputed. Who was the first aggressor, who escalated? It wasn't really disputed in this case. There was a video showing that there was this physical confrontation between defendant and victim up on the deck. There's no way to dispute that because it's on video. It shows them both coming down the stairs. And then the only thing we know about what happened down in the backyard is the victim's testimony saying, we went to different parts of the backyard. I was standing by the lawnmower and the defendant's wife came walking towards me. We were starting to talk and then the defendant stabbed me out of nowhere. And there was really no testimony or no other evidence to controvert that. So I'm not sure what real value evidence that 14 months later the victim pushed his wife during an argument would have had for the defendant's case. And I'm happy to speak on the other issue as well, but if there's no further questions, I'm also happy to rest on my brief.
Okay.
Could you just
Sure.
do us the favor of running through the defense of another issue?
Sure.
Because
Sure.
I do want to make sure that I have you down for why that would be.
Absolutely. So there are cases that clearly state that where the facts permit, a judge is required to instruct on defense of another, even in the absence of a request for the same. The case law is also very clear that this is not required where the defendant has not relied on or even mentioned that defense at trial, which I think is directly applicable in this case. And I cite the Norris case, a 2012 case, in support of that. And I think Kivlehand is also a good example, kind of in contrast to where it was required, even absent a request for the same.
Well, there are going to be cases where the evidence, I guess, would be more robust in favor of the defendant. But the scenario here where there's this barbecue, the defendant's or him and his wife invite people that folks want to leave. There's clearly an altercation going on between the victim and the defendant's wife.
Yes.
Wouldn't it seem, again, even though there are more robust cases here, couldn't, in the light most favorable to the defendant, we see a scenario where, father or not, he's approaching his wife. I mean, he's yelling at his wife. He's pointing at his wife. In the light most favorable to the defendant, isn't there a good argument here that he gets defense of another?
I'm not sure where the defendant's wife also testified, and she didn't really corroborate that version of the events. I mean, her testimony was a little confusing because she did say she got between them at one point, but that is not shown on the video. So it is a little confusing, but if the victim had credibly, and which was matched up with the video evidence, said, yeah, when they came down the stairs, the victim was continuing to yell at me, got in my face, was walking towards me. Sure, I could see a case where this instruction maybe should have been given, but that's simply not what happened in this case.
Thank you.
Okay.
Happy to rest on my brief. Thank you very much.